SJC 12700, Judy C. Lynch and others v. Keith D. Crawford and others.
Mr. Clerk, good morning.
Good morning, Your Honor.
Mr. Chief Justice, members of the court, my name is Christopher Clark. With me is my colleague Christopher Novak, and we represent the appellant, Dr. Keith Crawford, a volunteer member of the RoxComp Board of Directors. This case presents two issues for review. The first is a threshold issue of jurisdiction as to whether this case is properly heard as an appeal at this time. We think it is under the doctrine of present execution and also as a matter of the court's discretion. The second issue is whether the trial court erred in finding that there was sufficient evidence in the summary judgment record that would permit an issue of fact to be tried as to whether the willful conduct exception to the volunteer immunity statute applies here. We think the trial court erred, and there is not sufficient evidence from which a jury could find that Dr. Crawford engaged in willful conduct to violate the Wage Act claim, which is the sole claim remaining in this case. Turning to the first issue, that we believe this case is properly before the court today under the doctrine of present execution, consistent with this court's precedent. The two statutes that are at issue here, the first is the Federal Volunteer Protection Act, as set forth in our brief. The text of that statute and the significant congressional legislative history make clear that the statute was intended to provide immunity from suit and to protect volunteer directors like Dr. Crawford.
Can I focus on a factual issue that's bothering me a little bit, which is he's acting as the president as well as a board member. And I'm confused about what that means here. Particularly the state exemption statute talks about your service as a board member or trustee. The federal one is broader, sort of acting in your capacity as a volunteer. But when he starts acting as the CEO and president, doesn't he take himself outside of all of this?
So I think the answer is no, and let me answer it two ways.
Okay.
Let me start with the factual issue, and then we can apply it to the statute. For purposes of today's argument, we are assuming that Dr. Crawford was the president because there is a factual dispute about this. Were this case to be remanded and a trial to happen, we claim there's sufficient facts from which a jury could conclude he was not the president.
Right, that's a separate
Right.
issue.
So for today's purposes, we're assuming that he is the president. I don't think that he comes outside of the scope of the statute because he is a director and the president.
Well, but the state statute talks about you acting as a director. And if you're a director, you got to be careful about acting as a manager. That's a line you're not supposed to cross, isn't it? I mean, it may be complicated here because they're going under, but I just don't understand how he gets, at least under the state protection, as a president as opposed to as a director.
I think I would answer it this way. I don't think you lose your status as a director if you also become an executive chairman or you become a president. And I don't think there's anything in the statute that says if you're acting solely as a director. It says...
It does. It says 85K says, no person who serves as a director, officer, or trustee of an educational institution which is tax exempt and who is not compensated for such services shall be liable solely by reason of his such services as a director, officer, or trustee for any act.
I agree with that reading. Under 85K, which is what I'll call the educational exemption, and I don't think that is a statute upon which we are arguing for immunity. I think under 85W, where we are certainly arguing there is immunity, I don't believe 85W essentially...
85W says, no person who serves without compensation as an officer, director, or trustee of a non-charitable organization. But is he acting as a director or trustee when he's acting as president?
Well, let me answer it this way. I think that's an interesting intellectual question, but I would respectfully submit it doesn't matter. Because if you read the statute, what it doesn't say is, as an officer, director, or trustee only. It doesn't say that you can't wear multiple hats, and the minute you wear 2 hats, you lose all of your other hats.
But under the Wage Act, it matters a huge amount if you're acting as a president or as a trustee. We've been very explicit that presidents, that's who the legislature wants to be responsible for Wage Act violations. But we've also said trustees aren't responsible, So I guess I don't know if it's as intellectual as you say.
Yeah. I think in this situation, it might be because we were unable to find a case where a Wage Act claim is applied to a president who's working for free. I think it's a unique circumstance here, and part of the factual reality is, the institution was going under, as you said, Justice Kafka, and instead of doing what probably would have been the smart thing, particularly given the way this case is played out, resigning and just going on vacation and saying, I'm done, Dr. Crawford did what I think we would want people to do, and he leaned in and said, I'm going to step in, I'm going to try to get the grant, and as part of that, we need to fill out this form and sure put my name on it.
If I could, please finish, I'm sorry.
Oh, no, and I think in this circumstance, it's somewhat atypical that you're going to have someone acting as a president or a manager who is not getting paid anything, and we certainly couldn't find any cases where that had come up before.
Looking at 85W and the language that's used here, shall be liable for any civil damages. So it seems to be talking about immunity from liability with that language, not immunity from suit. And if you look at that language, it's sort of similar to the Marcus language dealing with the recreational land immunity issue. So when you look at that and deal with liability for civil damages, how do you take 85W and turn that into immunity from suit?
Yeah, Your Honor, it's a great question. I think it's a hard one, right? The text here, I think, is very similar to Marcus, and it does not have those expressions of clear intent, such as actions or trying to protect somebody from the litigation. I think the best argument here, and this is advanced by the Attorney General in her amicus brief, is to say, much like Marcus, you look at the legislative intent. And the legislative history associated with 85W is virtually non-existent. It doesn't help us very much. But what the Attorney General does point out is that 85W was enacted right around the time as the Federal Volunteer Protection Act, which is very clear in its intent. And as the Attorney General points out, and we think is right, 85W, its purpose here is to protect the officers, directors, or trustees of the nonprofit organizations. And so from that, you could read a gloss onto it that it is intended to provide immunity from suit. But I agree, it's a much closer call than I think under the Federal Act, which is crystal clear.
But aren't we governed by the Federal Act as well?
You are, right.
So we have not exempted ourselves from the Federal Act as the Federal Act allows.
Correct.
So the intent of Congress would matter to us as well in determining whether there's present execution.
I think that's correct.
Let's assume for the moment, and I'm only assuming it, that we do decide the issue. Under the federal statute, it does not, it specifically exempts any criminal conduct. Wage Act violation by a president is a strict liability crime. So how does the federal statute protect your client where there's at least a material dispute of fact as to whether he is the president and as to whether or not as president he is strictly liable for the failure to pay wages timely?
Right. I think a strict liability, and it's an interesting issue. We weren't able to find a case where someone was found to be automatically criminally liable because they violated the Wage Act. Right? There's this separate discretionary component where the prosecutors would need to bring a case. There would be due process protections. There would be an entirely different proceeding that would happen for due process reasons and others. I don't think it's a true fact that simply being accused of a Wage Act violation on a civil matter automatically turns into a criminal violation.
I'm
and
not sure I understand that distinction, though, because if the concern is if you do something willful, or the chief's point, it's a crime, then you don't get the protection, you don't get the immunity protection. It's the act that's, it seems, more important than whether or not a prosecutor within his or her discretion decides to seek an indictment or bring a criminal complaint.
So I'm just taking that hypothetical a step further. I think then what would happen is anytime someone is found to have violated the Wage Act, they are automatically found to have committed a crime and then fall outside of
No,
the...
you know, a jury would have to decide whether or not that happened. No, it's just an issue that's out there.
A civil or a criminal jury with different burdens of proof and different... I guess that's where I think the analysis becomes more challenging. I think, and this is what the trial court, and we submit, got correct, and the trial court said, look, there's no case cited in the record where anyone has ever said being accused of committing a crime and maybe even losing on the civil burden of proof and with civil discovery, that at that moment in time, that automatically reflexively disqualifies you from the criminal side. I think there's a much different standard of review and different levels of protection before we would be able to say that Dr. Crawford's conduct was in fact criminal. And I'm not so sure a civil jury would be the one to decide that. But
wouldn't that go to immunity from liability, not immunity from suit? If it's a discretionary call whether to bring a criminal action, and aren't you sort of putting the cart before the horse then? I'm confused. If you're giving immunity, you're not going to allow that process to proceed, right?
sure, and let me give you an example where I think you would see both of those. So say, for example, somebody was charged with a crime, we'll say a Wage Act crime, and the Attorney General brings an action, it's a criminal action, and wins, and the person is convicted of the crime. A year later, a civil suit is filed to obtain money damages. In that case, I think the complaint would plead that the person was convicted of a crime and therefore is exempt and cannot get the benefit of the volunteer protection.
But the language of the statute says the harm was not caused, meaning things which are outside the scope of the exemption. The harm was not caused by willful or criminal misconduct. It doesn't speak about a conviction, it speaks about the nature of the conduct. And if the violation of the Wage Act is criminal misconduct, even if it's not done willfully, why would that mean that a Wage Act violation is outside the scope, at least of the federal act? You'd still have to deal with the state charitable immunity statute, which has different language and speaks about intentionally designed to harm or to any grossly or negligent acts or omissions which result in harm. So
Yeah.
it seems to me that you're not going to be able to seek protection under the federal act. You may get present execution under the federal act because of the purpose language, but it seems as if you're going to prevail, you're going to have to prevail under the state statute.
Yeah, I guess where I'm still struggling analytically is how it can be criminal when no one has found it to be a crime.
And there are a number of crimes out there which people, in their wisdom, choose not to prosecute.
Sure.
But the mere fact that the AG has not prosecuted somebody on a strict liability basis does not mean that there's not a statute which provides for it to be a fine punishable, I believe, by a year or $10,000 fine. So, I mean, it's there. Well, let's turn to the state. Let's turn to the state statute, because the argument that the judge found is that there's a material dispute of fact, at least, is whether there was an intentional design to harm or to any grossly negligent acts or omissions, and he focused on the emails of March 25th and of 27th. If we accept your point that the conduct has to occur as of the date of March 22nd, and we'll hear from your brother as to whether that's appropriate, why can one not take the totality of the circumstances that Wiley, wages were due on March 22, which is the last date of employment. Wiley tells the board, including Crawford, that they don't intend to make the payroll until after the federal reimbursement is received. There's reason to believe the federal reimbursement is not going to be received before March 22nd. They're not paid for work. Turns out that there is $88,000 in the payroll account. Was that, by the way, enough to make payroll on March 22nd, do we know?
Even close. It's literally 7 figures, I think is what is being sought here. And I think the 1 week's worth of payroll, it was in the receivership action, millions of dollars were provided to these plaintiffs already.
4 weeks.
Yeah, so not even remotely.
Okay, so it's not as if they could have made payroll with the $88,000.
Correct. They probably couldn't have made part of 1 week's worth of payroll.
Okay, but is there any doubt that he, as president, knew that they were not going to make payroll on March 22nd?
I think let me answer it this way. I think there's sufficient evidence in the record from which a fact finder could conclude that the board, including Dr. Crawford, wasn't apprised by the CEO they hired to help run the distressed company that there was insufficient money. I think that's a true fact. I think you
But
can't.
was not or was apprised? I couldn't hear you.
He was told, and he had received the memo. I don't think you can go any further than that. All the emails say days later is there is some money in some account. What should we do about it? And here again, this is partially where I think the troubling policy consideration comes in. Dr. Crawford did what I think we would want non-paid charitable volunteer directors to do, which is lean in and try to help, fix the problem. If Dr. Crawford is found to be not immune and found to be potentially personally liable for millions of dollars.
How about, I'm unclear about that. I mean, suppose he's not found liable, it's immunity from liability as opposed to immunity from suit, right? So you're saying if he's not immune from suit, he has immunity, he doesn't have immunity from liability either?
No, I would not go that
Oh,
far.
I don't think so, right?
Yeah, of course not.
So if he is immune, not immune from suit, but immune from liability, why couldn't the problem be taken care of in case there is any liability by insurance?
That's a terrific question, and it's one that I actually asked as well. The answer is, in this case, the receiver actually tried to go after the insurers. Typical directors and officer insurance has a carve-out for employment accidents and liability claims, and the policy in this case had no coverage for that. The receiver actually engaged with Roxcomp's insurers and tried to get them to contribute. The insurer took a hard line and said, no, that's outside the scope of the policy. And I think the Attorney General raises a similar issue in her amicus brief saying, well, oftentimes these charitable organizations will indemnify officers and directors. And so if there were sufficient resources, well, that would be a way to go. But here the unique facts are, as Justice Kafka said, the organization was going down. The smart thing for Dr. Crawford to do probably would have been to resign from the board and go on vacation.
Step away, yeah, just step away.
Right, it would have been, we wouldn't be sitting here today.
There's also a point where he had a choice to make, though, about where money was going to go, and it could have gone to the employees rather than the vendors. Isn't that right?
No, respectfully, Your Honor, I think that's wrong. I think all the record says is somebody told him there was less than $100,000 sitting in a bank account. That's the limit of what the record evidence says.
Okay, so let me just make, this is a point which I don't know was discussed in the brief. So he was president and on the board. He's told we're not going to make payroll by March 22nd. And although it probably was not discussed that way, that would be a Wage Act violation because these folks are working and they're not going to be paid on their last day. What do we do in a world in which there just ain't any money to pay them? Is the president liable under the Wage Act where there's no money to pay them? If you're saying that the $88,000 was insufficient to make payroll, what do we do with that?
Well, let me answer it 2 ways, because that's the interesting practical question here. I think the short answer is if you were to strictly read the Wage Act, I think the answer harshly is yes. I think the answer is,
Isn't that the purpose of that provision?
Yeah.
Which is, it says, okay, you shouldn't have people working if they're not getting paid. So if you do, you're going to have to pay them out of your own pocket. The Wage Act is harsh, but isn't that what the legislature meant to do? And doesn't your client take on this huge risk when he leans in as opposed to doing the cautious thing, which is just letting it go belly up.
Short answer, yes. I think that's exactly right. But like many schemes, we look at the pieces and how they fit together, and that's exactly why volunteer immunity comes into play. We have said, look, if this was a CEO making millions of dollars a year, maybe there's some levers to pull here, but that's not this. This is a gentleman who spent years of his life investing in this community to provide services to underprivileged people who needed basic medical treatment, never got a nickel, and instead of pulling the ripcord and leaving, as I think every prudent lawyer would have advised him in the future to do, the guy says, I'm gonna try to get this funding, I'm gonna try to stay here and try to make it work. That's where the volunteer immunity comes in to balance. It's essentially a carve-out that says, as to these specific individuals and this class of people who are doing good, we are going to make sure they are protected.
So you're saying then, essentially, that there should be an exception to the Wage Act for an unpaid president or director of a nonprofit?
I'm saying that's the outcome. I'm saying, I might phrase it differently, which is the Wage Act, the text says if you wear the hat of a president, you are personally liable for the wages.
Right.
However, through these other policy legislatures at the state and federal level have created an immunity and a carve-out to say that as to those individuals, they should be immune and they should not have to step up. And oh, by the way, in this case, the plaintiffs actually did get paid, albeit late. They got roughly 1.4 times their wages.
Okay,
So,
but that's not, I mean, that's irrelevant for purposes legally. Do you agree?
I agree.
I mean, late payment, the fact that somebody ordered them to pay and they did doesn't change the fact. It was only after Judge Fahey ordered them to be paid that they were paid.
Correct.
So, but then what do you do with the exception in 85H? It said, 85W does not say it's a total exemption. It's a total exemption, but shall not apply to acts or omissions, and it specifically refers to omissions intentionally designed to harm or to any grossly negligent acts or omissions which result in harm to the person. So it would be stronger if it didn't include that exception, but it does include that exception. So what do we do with that?
I think on this fact record here, I think it's actually an easy one because there is no evidence in the record. So you can imagine a different factual record where this email comes later in time and the person writes and says, thank you so much, I appreciate we had a meeting last week. Thank you for not paying wages as I instructed. We really need to save that money to pay other vendors. So under that scenario, I think Your Honor's hypothetical is spot on and the volunteer immunity probably falls away. But on this record here, there is not one single piece of evidence as to Dr. Crawford's intent to violate the Wage Act and not pay wages.
But that-
it doesn't, I'm sorry, go ahead.
Isn't that the whole point of the Wage Act? The intent really isn't much of an issue, is it, with the Wage Act?
I agree as to the Wage Act, the intent doesn't matter at all, that's why it's strict liability. But I think what we're dealing with is the intent component of the volunteer immunity. I think for purposes of today, we all have to agree at the summary judgment stage on this appeal, Dr. Crawford was the president, he would be personally liable, it is strict liability, he owes the money. So I think we all have to assume that for today. The intent question comes as to whether or not that is 100% immune from either suit or liability under the state or federal immunity statutes or not. And that's where I think the intent issue comes in.
Chief, can I ask one additional question? There's probably a simple answer to this question, but summary judgment's denied because the judge finds that there's a material fact as to willfulness. So this is a present execution question. That means that there's going to be a trial. So what's the importance of immunity from suit here when there's going to be a trial anyway?
In this particular case, I think your observation and a comment is an apt one. I think in other cases, and we've seen this happen in the past year in the trial court, you would expect this issue to be raised earlier at the motion to dismiss stage, right? You would expect someone to say the complaint does not plead sufficient facts from which you could claim someone acted willfully. In this case, I think it's a bit more academic, but in terms of setting policy for the Commonwealth and guidance for the courts going forward, I think the issue is still a very important one.
But you're claiming that your client is immune from suit.
Yes,
And you're claiming that we should, in this appeal, say that the judge was wrong in finding that he was not immune from suit.
correct.
And because it's a qualified immunity, isn't it almost always going to have to be decided on summary judgment? Because there are going to be issues to resolve as to whether or not the exceptions kick in.
Respectfully, no. So imagine a complaint that is filed that doesn't have sufficient factual allegations.
Right, okay, I get that, okay. And certainly in the Brunn case, qualified immunity,
Correct.
judge, this court reversed me as a Superior Court judge who denied the motion to dismiss, so.
I didn't cite
so
the-
I
I
know
didn't
what
bring
could
that
happen. All right, thank you.
Thank you.
Mr. Galaboy.
Good morning, Mr. Chief Justice. May it please the court, Andrew Galaboy on behalf of the 16 former employees of Roxcomp who were not paid for their final 4 weeks of work and their vacation pay at the time Roxcomp closed on March 22nd, 2013. In this appeal, we urge the court to reject that there's a right of appeal here under the doctrine of present execution. I think as the court has laid out, there are strong arguments as to why the immunities that are claimed, which are generally, I'd say, wholly unique to the factual pattern in this case, which I think my friend acknowledged several times, that there's a very unique fact pattern here, and that therefore there is no right of immediate appeal here. However, since we're here, and several issues have been addressed, I think are important to.
Well, before you leave that, I mean, if it's qualified immunity under state tort law, and I mentioned Brunn, there is a right of present execution. So why would we say that there's a right of present execution for qualified immunity involving state employees or even state governments, but not with regard to charitable employees who are giving their time?
I think with respect to that specific question, the comparison to the Brum case,
Well,
there's.
it's broader than Brum. I mean, in all state tort claim immunity, qualified immunity cases, and whether it's a police officer, we would say we will take those cases.
Certainly, Your Honor. However, based off the language of both the state statute 85W and the VPA, these are protections from liability. Essentially, they're statutorily sanctioned defenses, willful conduct, criminal misconduct, intentional. Those are immunities from liability. Indeed, in both the VPA and the state statute, the titles reference tort liability, not immunity for if you accept the role as a prosecutor and you make a recommendation to the court, you become immune from suit for whatever recommendation you made. Here, we're talking about defenses that are supplied. And in this case specifically, as this court has articulated the doctrine of present execution, one of the key facts is that it has to be collateral to the issue. If we go back down and have a trial, the entire trial will be about whether Dr. Crawford acted willfully or intentionally. If this court were to decide that the VPA has application to this case, or that 85W has application, the trial will be, did he act willfully or intentionally? And I think that's by definition not collateral, and therefore sets apart these statutes from the statutes where this court has found that the doctrine of present execution applies, whether it's to state employees or in the Maxwell case where the statute created an obligation on insurers, or the workers' comp statute, which creates an obligation on employers to maintain insurance and then also to waive blaming workplace accidents on their employees.
Are there cases, though, that seem to indicate that when you're dealing with an issue of immunity, that the underlying action and the immunity, that it's collateral? Aren't there some cases that say that, sort of by definition?
I think when you're dealing, I think there are cases that say that when it's clearly an immunity from suit. And I think the analogous situation is the Marcus case, where the immunity was a liability immunity if the municipality doesn't charge for use of its, in that case, a softball field. There was a dispute as to whether it was used for free or not, whether the payment made to a third party constituted a payment, but the use was still free. And I think that highlights what an immunity from liability is, and it's analogous to what we have here. Is that
Now,
when it,
since, before you get into the details here, I just have a big picture question. Let's say that you're correct about the present execution. Let's say that we agree with the appeals court. What do you think of the standard that was outlined that tries to reconcile or tries to address the Maxwell-Marcus issue?
I think the appeals court dealt with the harmonizing both Maxwell and Marcus nicely. I think they basically said, if it's not entirely clear whether it's immunity or liability, however, if the statute imposes an obligation, like in Maxwell, of requiring insurers who may have reason to believe that there's been fraud to report it to the Fraud Bureau. In Marcus, there is no affirmative obligation created on a municipality.
Isn't that really out of left field, that distinction? I mean, it doesn't seem to have any basis in anything that's been out there before. I mean,
I agree. I think the appeals court looked at this and said, we have an SJC decision from 2011, Maxwell, an SJC decision from 2012, Marcus, where statutes have similar language where they refer to liability, but in one case, the court determined that it was, in respect to Maxwell and the Fraud Bureau, that it was actually an immunity from suit based off the whole reading of the statute and also the fact that an obligation was imposed.
it just seems like focusing on that one little distinction doesn't seem to really, I mean, it's really a question of legislative intent, right? And all the way the statute is designed and what it's trying to do.
Correct, and I think that's what the appeals court
Now,
endeavored to do, since they struggled, I think, with.
I understand we confuse them because one case doesn't even cite the other, and I get that, but
Is there another way to reconcile it, though? In Maxwell, the statute uses the word subject to liability. Could you say subject to liability might mean arguably from suit, immunity from suit?
I think you'd have to look at the whole phrase to determine that, not just try to limit it down to just subject to liability, because the statutes here talk about limitations of liability, and then is that a difference without a distinction? I think you'd have to
But
dig in.
Marcus, it says, the statute in question, Marcus says, shall not be liable.
Correct. And that's, I believe, the exact language we have in 85W, and is consistent with the VPA, the federal statute, with section, is entitled limitation of liability, and it has very similar language as well. And I think that takes me back to my original point, that these are essentially statutorily created defenses that are advanced either at summary judgment, or where there's a dispute of fact, you then move to trial, where they become jury questions, if the statutes apply. And as we argue below and we argue to this court, they don't apply. And if they don't apply,
Well,
then
the statutes apply. You're claiming the exemption kicks in. It's not, you're not claiming the statute doesn't apply, are you?
no, we're claiming the VPA is not applicable for two reasons. One, that it should just relate to torts. This Wage Act is a statutory claim, not a tort claim. And two, as your Chief Justice pointed out during the argument of my brother, the criminal conduct exception. If under the VPA, you cannot invoke that immunity because of criminal conduct, and the Wage Act violation is criminal conduct. The act of not paying wages is the conduct. And here, and this is important, as there was a lot of discussion when my brother was speaking, is it's not disputed the wages weren't paid. So it's not as if there needed to be a criminal trial with a burden of proof for a jury to determine. It's undisputed. The summary judgment record is clear that it's undisputed that from February 25th to March 22nd, wages were not paid.
But we have to do we have to make two different levels of analysis, right? We have to decide, I take it your view is there's neither immunity from suit nor immunity from liability here because of these exemptions kick in. I'm leaving your VPA doesn't only applies to tort aside, but the problem we have to decide is, don't we have to make a determination whether you can bring that challenge under a present execution? Whether the exemptions apply or not, wouldn't we still have to decide whether it's present execution applies? Because where there's factual disputes about that?
Yes, I think the first level of analysis is whether present execution applies, whether jurisdiction is appropriate.
Right.
However, in both the Maxwell case and the Marcus case, the court said, we're here, there are other issues addressed of importance, let's decide them. Even though in Maxwell, they addressed issues beyond what present execution related to. In Marcus, they addressed the issue, even though the court said present execution doesn't apply.
I mean,
So,
you
so
could,
if we don't do that here, suppose we stop with the question about the the doctrine of present execution.
If you stop here and say present execution doesn't apply, we go back to where we were nearly 3 years ago, where we're getting ready for a trial, where there will be issues related to the application of the VPA and 85W in the context of jury questions,
So I
jury
guess what I'm
instructions.
asking you is, do you want us to go beyond the question of, I mean,
I-
assume we agree with you that there is no really right of present execution, should we exercise our discretion here?
I believe so, since we're now with the highest court in the Commonwealth, and there are issues that will govern how this case will proceed if it goes either to trial, or as I believe, if this court were to determine that the VPA or 85W are not applicable, I think the natural consequence is that the case ends with judgment in favor of the plaintiffs.
So basically what you're saying is that the question of the doctrine of present execution is really irrelevant here? because you-
I think with respect to the specific factual scenario, now that we are in front of the SJC, I think in many respects it's irrelevant to this case. The question is,
that
what
right?
happens in the next case?
is that right? Because couldn't you lose the present execution argument, meaning that it should be brought up to us, but we still decide that the exemptions are triggered here, or at least they have to be tried? I mean, the case could be properly before us. Let me pose the following hypothetical. The guy was only acting as a director, comes to us because we conclude that present execution requires either the federal or the state exemption statute to be brought to us because it's an immunity from suit issue. But here, because we have a factual dispute about whether he's acting as president or trustee, all of this needs to be tried, right? So even though the issue was probably brought before us, we say, hey, still, he could be outside of everything, right? Or am I missing?
No, you're exactly correct, with the caveat that if you got into the analysis of the summary judgment record, whether you're affirming or denying or reversing the trial judge, since you're entitled to affirm on any basis in the record,
But we have.
this court could reach the conclusion that the
Of their-
VPA and 85W don't apply.
Not if there's not material, if they're material, right, I guess, but if they're material disputed facts, we can't do anything.
Correct, I absolutely agree with that. If it is a factual dispute, then we go back to where we were.
But I want to follow up on Justice Kafka's question, ask you the same question I asked the appellants. So is there present execution if, based on the decision at summary judgment of the Superior Court judge, and if we don't get into the merits, the case is going to be tried, period. So what's the point of addressing whether this is, immunity from suit or from liability, because it's not present execution, because it's going to be tried. Look at the decision of the Superior Court judge, and we're not going beyond the present execution issue.
If this court were to stop present execution, say present execution doesn't apply, I think you're correct, we're going back. We're where we are in January 2006.
No, but I'm asking you whether present execution applies at all when the case, based on the Superior Court judge's decision, has to be tried, period, because there's a material fact issue on willfulness.
Well, I think present execution is triggered by the statute invoked by Dr. Crawford, not the decision by the judge. So present execution gets you in the door based off the statute, but ultimately, whether the door is closed, saying present execution doesn't apply, or if this court does say it applies or it exercises its discretion, but then says there's a material issue of fact, we're going back.
What do you do with the findings of the Congress with regard to the Federal Volunteer Protection Act that speaks of the concern with high liability costs and unwarranted litigation costs? Volunteers and nonprofit organizations face higher costs in purchasing insurance through interstate insurance markets to cover their activities. Doesn't that speak to the concern about the cost of litigation as well as the cost of liability?
I would say that in that same report, They say that this is designed to protect against claims of ordinary negligence. So they are defining a very narrow scope of what the committee believed the bill would be advanced.
I understand your point that it doesn't even cover statutory claims. Let's assume you lose on that.
Okay.
I'm not saying you will, but let's assume we reach the issue and say, no, it applies to all civil claims, whether it be a statutory 93A type claim or a common law claim.
Yes.
What do you do with that finding? Because your brother says, aha, that finding indicates that the Congress was concerned about immunity from suit as well as immunity from liability.
I think that interpretation wouldn't be consistent with the actual language that is in the bill. In section 14501 talks about protections from liability. Section 14503 is entitled Limitation on Liability and Liability Protections. I think ultimately the bill there is, the actual statute is clear that it's a protection from liability that creates a certain defense from a claim. And in this case, the position is, the trial judge found there were material issues of fact as to whether they're entitled to invoke that statute as a defense because of willful misconduct or in the state statute, intentional misconduct. And that is how that dovetails with my overall point is that if the VPA doesn't apply or the 85W doesn't apply, the natural consequence is that the plaintiff should win because it's not a question of fact whether someone is the president of an entity.
But if you have a vanilla claim, not this one, in which somebody seeks to sue the president or a director of a nonprofit because of a common law negligence claim, and the judge, for whatever reason, denies the motion to dismiss or for summary judgment, then that person would then have to go to trial in order to be able to appeal the fact that that case should never have been brought in the first place. I mean, that's the consequence of there being no right of present execution.
Correct, I agree with that.
And the question is, are we prepared to bear that risk with regard to volunteers? Or at least, I guess, more precisely, did Congress or the Massachusetts legislature wish them to bear that risk with regard to volunteers?
I believe the answer to be yes, that they did they did expect that risk would be borne, but as I think you correctly point out, in a vanilla case, the situation would likely be addressed on a motion to dismiss or a motion for summary judgment, because you would not have the unique factual pattern here of Dr. Crawford becoming the president, not just a member of the board of directors, signing documents under the penalties of perjury. And under negligence claim, there would have to be more than, it's not a strict liability action. So the Wage Act, the confluence of the Wage Act makes this even more unique circumstance beyond the fact that we have a president of an entity who's not being paid.
And what do you say to the Attorney General's letter to the contrary, especially considering her role when it comes to charities?
I understand the Attorney General's position and the role they play. However, I'd note in the letter that they sort of expressed the conclusion, but then took a step back saying, but we take no position with respect to whether this issue is collateral, which is critical to the determination as to whether present execution applies. I don't think you can have it only halfway in. I think this court has created the doctrine of present execution and set forth two prongs to look at. The Attorney General essentially said, we don't want to look at the second prong. So I respectfully understand their position, but I think it is not of great weight in the consideration of this matter.
All right, thank you.
Thank you.